Beatrice is doing a lot of propaganda this morning. Beatrice, I must put it on record.
Just say the facts.
Beatrice, Samir, and I are actually very good friends. We go way back. It appears that while matters progress, things are taking a different turn in respect of this particular matter.
If you can,
have been re-narrated.
Wilberforce, kindly speak up for me a bit. We're struggling to hear you.
Okay.
Thank you.
Is it better?
Yes, better, much better.
Very well, very well. So I just want to, I only joined in at the latter part of Beatrice's submission. There were other facts that Beatrice has misrepresented to the public. I would not be.
I'm sorry, reposition yourself. I think I'm losing you. Are you moving from where you were?
I misrepresented. He should answer.
I'm moving around, so I don't know whichever one is better for you.
I'm sorry. Can it move a bit or be stable?
I've actually moved outside now.
Okay, so stay there.
Is it better?
Yes, it's better.
Or you have to call back?
No, it's better. It's okay.
Very well. So at least two things I've heard Beatrice say at the latter part of her submission was that it has never happened that it has never happened because I think it was in respect of the communication between the Attorney General and the accused person that it has never happened, not even in Gloria Kufuor's time. That's what she said.
Mm-hmm.
And it has never happened because this is a negotiation under Act 1079. And Act 1079 came into force in 2022. 22nd July 2022 was when this act was assented to. So obviously, it would have never happened prior to that. Now,
if you can, for the purposes of our viewers, if you can quote the act for me.
So the act is Act 1079. What is being referred to as the Plea Bargaining Act. But it's actually an amendment to the Criminal and Other Offences Procedure Amendment Act 2022. And the date of assent of this act by the President of the Republic was 22nd July 2022. So obviously, it couldn't have happened prior by any other Attorney General. So let's just get that aspect correct.
Okay.
And also the issue of the Supreme Court judge is also another thing that I caught in her submission. The Supreme Court judge, we have stated that the meeting at the Supreme Court, and let me put on record that there is no law anywhere that says a lawyer or a prosecutor cannot talk to a judge. I hope Beatrice will be able to quote the law for us so that we all learn. I don't know any law that says a lawyer or a prosecutor is not supposed to talk to a judge. There are instances where, in fact, the Attorney General is on committees
Isaac,
with several of these judges.
I'm sorry, let me come in here. How about Code of Ethics?
There is no law in the Code of Ethics that says a lawyer should not talk to a judge. It's not there anywhere. The only issue is a judge in the matter that you are engaged in. You don't have quote and unquote secret conversations or ex-parte communications with a judge in a matter that you are engaged in. But no law says no lawyer should talk to any judge. I mean, there are conferences held between judges and lawyers. There are committees that judges and lawyers serve on. Mm-hmm. The Attorney General is on the General Legal Council with the Chief Justice. So on the panel, they are not supposed to talk or what. So that issue also needs to be corrected.
So did the Attorney General meet with the third accused in the House of the Supreme Court, the said Supreme Court?
Absolutely. And that's information that, very well, yes, that's information that we put out there ourselves after the Director for Communications for the NDC brought in the issue of the Superior Court judge. Nobody, this information of Superior Court judge actually goes to the benefit, if there's any argument at all. I don't see any arguments going on actually. But the narration itself, of course, will favor the Attorney General or goes to the benefit of the Attorney General, the inclusion of this Superior Court judge.
Okay.
And
so
the Superior Court judge was only mentioned. No, I've seen a statement by Sami Jemfi, that why is the Attorney General bringing in or trying to implicate a Superior Court judge? Why is he bringing in the issue of a Superior Court judge? You should name the Superior Court judge. Nobody mentioned Superior Court judge until the night of 23rd May 2024, where he himself, Sami Jemfi, who is now turning around to say, why is the Attorney General bringing in Superior Court judge issue? Sami Jemfi was the first person. Go and check Joy News, the evening news program that they do. 23rd May, I was on the program with Sami Jemfi, where he was the one who first mentioned the issue of Superior Court judge. Now, what we are saying in respect of the Superior Court judge is that it is this same Richard Jakpa who requested through the Superior Court judge. So the Attorney General gets a call from a Superior Court judge. He goes to the house of the Superior Court judge. Jakpa shows up at the house of the Superior Court judge. Now, this is a point. This is at a point. Let me just narrate the issue correctly so that the whole confusion in the media, or not in the world, the whole confusion that's being re-spun out there, or that's being spun out there, would be corrected. The negotiations started under Thomas Obin. This is an accused person, A3, who has changed lawyers several times. So there are many instances in this case that the accused person was not represented by counsel. What does the law say? So they should refrain from this whole Rule 13. The law says that you can negotiate with the accused person or counsel for the accused person. This is contained throughout the Act 1079. So you can negotiate with the accused person. The law allows that. Plea negotiations can go on with the accused person.
The law allows that within a 30-day period, right?
That is not true. The law says that you can bring this plea negotiation to the attention of the court. The court can stay proceedings for 30 days. After 30 days, the court may, it doesn't even say shall, the court may continue proceedings in court. So what that 30-day rule is saying, and it's good you have brought it up, so I can explain this to the public. What the 30-day rule is saying is that if after 30 days, from the commencement of the plea negotiation, an agreement is not reached, the court may continue the proceedings. That's what it's saying. And it doesn't stop the negotiations from going on. If you look at section 162A, it says that these negotiations can go on even up to the day of judgment. It means it can go on throughout the entire process. And we saw that in the Atuasian case. The negotiations went on even close to probably the day before judgment, the negotiations were still ongoing. So it can go on any time before judgment. So the 30-day rule is in respect of whether it's in respect of staying proceedings at the court. So the fact that the court continues proceedings does not mean negotiations have ended.
Okay,
now,
so
go on.
Okay, clarify this for me. When did the plea bargain period end? And when did this meeting also happen at the Supreme Court's judge's house?
The plea bargaining period, I've suggested, that has not ended, because let me tell you what happened. So, like I was saying,
you are saying that.
No,
when you are saying, no, I just want some clarity. You are saying that within the 30 days, even if it ends within the 30 days, the court may allow continuous negotiations, right?
No, not the court may. The court is not in a position to either allow or disallow negotiations. Okay. The law places the onus of negotiation on both parties in the matter. Okay. The judge is a trial of facts. The judge is not in the arena of conflict. So it's the persons in the arena of conflict, being the accused persons and the prosecution, that negotiates. So what the judge does is that she may continue the process in court, or she may, you understand? So the judge's role is to continue the process in court. That's what the judge does.
Is that to say that the plea of bargain never ends?
The plea bargaining law, let me just read the law to you. It can happen anytime. So section 162A says that subject to 162B, a person charged with a criminal offense may at any time before judgment negotiate with the Attorney General for a plea bargain. So the negotiation goes on, or it can go on before judgment.
All right, so at what point,
the process is continuing in court, it does not stop the plea negotiations from going on.
All right, so at what point will a senior lawyer like Martin Pebu describe what happened as what you lawyers call subordinates? It's like you are compelling. Is it subordination? Yes. You're compelling the accused.
That comes in with the greatest respect to Martin. And I'm saying these things is all because of the misnarration of facts that have actually taken place. this whole suborning issue comes in when you have, for instance, when you have fabricated evidence. Okay, and let me point out at this point that even the accused person himself, Richard Jakpa, under oath, under testimony, never said that the Attorney General has fabricated evidence. Or the Attorney General asked him to fabricate evidence.
From his accounts and as carried as his testimony in the correspondence in the court, you could tell he was very angry and he sounded as though someone who is being compelled. And so maybe, I mean, we'll leave that with the courts. But with the accounts, his accounts and the words he used, it sounds as though the Attorney General was trying to get him, fabricate a story to jail the first accused or the A1.
Who is angry that he's being asked to fabricate. Me, from what I see it as somebody who is angry that he has made several approaches to the Attorney General for plea negotiations, for an agreement to be reached, and the Attorney General has not budged. That's how I see this.
Okay.
So I see his anger as somebody who is being prosecuted, and I can't control his anger.
No,
how many? Okay, it's up to him.
How many times has he negotiated with the Attorney General's office, or attempted, or whatever? I mean.
So let me just continue the narrative to answer all these questions. So negotiations started under Thomas Obin. This is at a point where the same Mr. Jakpa had fired lawyers several times, about 2 or 3 lawyers. He started with Tumisi, and then reigned up Tumisi also. Then he went on to what's his name? There's another lawyer he went to before even engaging Thomas Obin. I think the other lawyer was one called Kosa, I think. And then he brought in Thomas Obin. Thomas Obin wrote these letters asking for plea negotiations. I've also heard Felix Kwachifos to say several times that Richard Jakpa was not even doing plea negotiations with the Attorney General. Let me correct that. It was plea negotiations. There's a letter, I think, dated the 16th May letter or so, where Thomas Obin clarified that, yes, what we are looking for is a plea bargain. It's very clear in that letter. Initially, the Attorney General was asking you, are you coming for plea bargaining or what? You are bringing in a third party. The third party is not a party to this case. You are bringing in Big C. Big C is not a party to this case. Act 1079 does not include third parties. Are you plea bargaining or not? And he makes it clear in that letter. Yes, what we are asking for is a plea bargain. Very unequivocal. What we are asking for is a plea bargain. Now, in respect of, let me even read that portion to you. For the avoidance of doubt, and this is a letter from lawyer from the third accused person, Richard Jakpa. For the avoidance of doubt, our client hereby confirms that while the proposal originally emanated from Big C, our client has wholly adopted the proposal and we therefore consent to the authority of the third accused person to plea bargain. So it is there. So where from this third accused person never plea bargain? So then the negotiation was going on with Thomas Obin, and then Thomas Obin was fired. Jakpa fired Thomas Obin. So all the meetings that were had, with the same Mr. Jakpa, was at a time that he had no legal representation. And the court documents will bear that fact out, that even when he opened his defense alone. He gave oral testimony. He did not have a lawyer at the time. The court record will show that there were several instances in court that he came unrepresented. So during that period, if he met with the Attorney General, at his own request too, let us make that also very clear, at his own request, he met with the Attorney General at the time he had fired his lawyer at a place that was in a Supreme Court judge's house, and this Supreme Court judge is his own relative. He met in the house of his own relative. Now, if the Attorney General, in accordance with law, continues negotiation which had been started by Jakpa himself, where's the issue here?
So hold on. Whose relative are you talking about? Is it the Attorney General's relative or Richard Jakpa's relative?
Richard Jakpa's own relative.
So Richard Jakpa's relative is
Richard Jakpa's own relative's house.
Okay, so hold on.
At his own relative's house.
Right. So the Supreme Court judge is Richard Jakpa's relative.
Absolutely.
And the Attorney General invited him into his own relative's house.
No.
Who is a Supreme Court?
The Attorney General was the one who was rather invited. Thank you for even bringing that point out clearly. It's the Attorney General who was invited. So to come to court and to quote and unquote throw tantrums to say that, and you met me at all places at all hours, really, all these meetings were at your own instance. And it was for your own benefit. The Attorney General had closed this case. There are documents that have been tendered into evidence that already support the Attorney General's case.
All right, so just to put it on record, Richard Jakpa went to his uncle, who is a Supreme Court judge's house. Uncle, yes. And the Supreme, and invited the Attorney General, who is prosecuting this case, right?
I've said relative, I've not said uncle, please.
Oh, okay, relative. All right.
Yes.
And when was this?
When was this?
Yes.
I'll not be able to give you the time and the date, but it happened. We have not denied the fact that it happened.
Was it this month?
Like I said, I'll not be able to give you the time and the date, but it was during the period where our friend and the accused person was not represented by counsel. So it was during that period. When was it? It's actually, with the greatest respect, it's actually material to the substantive arguments being put out there. With the greatest respect, Annie.
Material.
It is material, Wilberforce.
I've explained. So if I say it was 1st May, it was 17. What difference does it make to the substance? If you want, you know what? I'll get you that information.
Because you're saying that in this
case.
Don't
worry, Annie. I'll get you that information.
Okay, hold on.
I have your number. I'll get you that information.
Because you're saying Richard was the one that did the invitation. I don't think.
But there are letters to show that Richard was the one who initiated the plea bargaining agreement, and the fact, and we are saying, which has not been denied by Richard, unless the NDC are now spokespersons for Richard Jakpa.
Okay, so
because Richard has not denied, we have put this out in the public.
Richard initiated a plea bargain, but you have not. That's the Attorney General's office has not done that.
We have not done what? Sorry, I can't hear you.
You are not negotiating, are you? Or you're not?
Oh, to the best of our knowledge, we were negotiating. The way things have turned out, it would seem quite impractical for such a negotiation. Remember, these negotiations are supposed to be without prejudice, are supposed not to even come to court at all until an agreement. It's the agreement that comes to court. So for you that you requested a negotiation, for you to come to court and throw tantrums, it's quite sad and confusing.
And both parties were doing the plea bargain with their counsels involved, no?
Oh, I've already explained that at the material time, the person was not represented by counsel, and the court documents will show that there was a long period that he did not have counsel. These are all records before the court. So both parties were not represented by counsel. Prosecution is already counsel. The other party, when it started, he was represented by counsel. That's Thomas Obin. And the negotiations were going on with Thomas Obin. There are documents to show. And when he wasn't represented, the law allows you to negotiate with the accused person or the counsel. Maybe I should just read that portion of the law. But Beatrice knows that you can have these negotiations either with the accused, well, she knows or ought to know that you can have these negotiations either with the accused person or counsel for the accused person. And when he got legal representation again, when he engaged Tadio Sori again, negotiations continued with Tadio Sori. So where is the conduct that's unprofessional here? Or where was this?
Let me find out. Why didn't the Attorney General was in court, right, when these testimonies were being given by the third accused? Why did he not stand up to it or put up a defense since it was being captured?
For that question. It's good you are helping me cover everything that ought to be covered. Now, in court, it was not the Attorney General who was cross-examining the accused person. It was Edujita Maklu, who is counsel for the first accused person, Honorable Atoforsen, who was doing the cross-examination. Attorney General time to cross-examine is scheduled for Thursday. That's this week, Thursday, this Thursday coming. So the Attorney General should tell Edujita to sit down and he Attorney General start cross-examination or what? No. The Attorney General is a very experienced lawyer.
But there's nothing wrong with calling for an objection and making a case or a defense, since there is a direct attack. There's a direct attack. Hold on.
Let's not do that.
I'm saying that there is a direct.
Let me just put it this way: the neutral lawyers and even the partisan lawyers, either party, they know or ought to know that the proper time to question such a statement that has been put on record is under cross-examination. Why would the Attorney General object when he's not the one doing the cross-examination? No, that's not how we do it in the legal profession. His time will come. His time, and in any case, the matter that was raised by Japa, that they met, the Attorney General has not denied the fact that they met. So it's not true. The narrative being spun by my friend Beatrice, it's not true that the Attorney General has denied. He has not denied. He said he has not met the person with the aim to. There's a difference. There's a very big difference there. Let's get the narrative right.
The release from the Office of the Attorney General was seeking to attack the NDC instead of the businessman that was involved in fact, the one who was giving the testimony. How did it, all turn to the NDC as a party?
Oh, as to information that came out as a result of that press release, these are factual information, or this is factual information, and it's immaterial right now to the substance of the issue. The Attorney General's focus is on delivering his mandate under Article 88 of the 1992 Constitution, and he's doing so in accordance with law. So far, what they have said is that one, fabrication of evidence. I have pointed out to you, you have read the statement yourself, I believe, what the person said in court on oath. He never used the word fabrication. That's very clear. And from what he said, you wanted me to implicate X. Now, if I tell you what the Attorney General told him is to that, say the truth. When I ask you a question on this document, say the truth. Don't be cunning, don't be coy, say the truth. If I ask you to say the truth, and the truth will implicate the person, how is that telling somebody to fabricate evidence? When the Attorney General has already closed the case, that doesn't even add up. Now, two, that the person met with an accused person. I've already showed you that under Act 1079. In fact, that's the whole purpose of the Act, the Act 1079, which was passed in 2022. The whole purpose of the Act is for the Attorney General or prosecution
but trying to tell someone.
So where's the issue here again?
Okay, but trying to tell.
Now, the third issue is that he met without the person's lawyer. We have already established also the court records are there. You can apply for the court records. We've already established also that there were long periods. This person has sacked his lawyer. He had gone to about 4 or 5 lawyers. And during that period, Attorney General started negotiation with his lawyer. He sacked that lawyer. Attorney General continued the negotiation with him as is permitted by law. And now the Attorney General continued with his current counsel. And his lawyer on the day, after he threw those tantrums, his lawyer on the day came out to apologize to the Attorney General.
Okay, Wilberforce, can you hear me?
Yes, I can.
So, lawyer Eric Delalifo says that, Annie, is Wilberforce suggesting that the AG, that's the Attorney General, who knew that A3 had always, that's Mr. Richard, always chosen to have a lawyer and had indeed engaged lawyers to represent him, waited to ambush him, the A3, at a time he briefly lost the services of his last lawyer to harass him into incriminating a co-accused person?
You see, this is the statements, these are all the statements that is being thrown out there. The statement that he had always chosen to be represented by a lawyer, when I've established, even pointing you to court records to show that there were several instances that he did not have a lawyer. He opened his defense. The person actually opened his defense. This is at a time that anybody would even want to have a lawyer. He opened his defense without a lawyer. He gave oral testimony in court without a lawyer. Check the facts. These are facts. These are all out there. So the narrative that he chose to meet this person without a lawyer, Madame Delali, is wrong. This person did not have a lawyer at the time. Attorney General met him at the time he did not have a lawyer. And it was at his own request. It was at his own request. So, please, when you look at what I've narrated to you, really are there. What's outstanding? Really what? That a lawyer is not supposed to meet with a judge. Really, Beatrice? Really?
No, maybe before you go, when an accused person doesn't have a lawyer or have lost the lawyer due to some circumstances, is it allowed to, if you're still dealing with plea bargain, is it allowed to still meet the person without his counsel?
Thank you very much. In fact, when you look at the plea bargaining law, priority is placed on even the accused person before the lawyer. Let me even read Section 162A to you. Section 162A says that subject to 162B, a person charged with a criminal offense A person charged, is it the lawyer that has been charged? No, it's the accused person. A person charged with the criminal offense may at any time, before judgment, negotiate with the Attorney General for a plea bargain. And that's what has happened. If you look at 162C, let's even look at 162C. 162 says here that, wait a second, 162C says that the plea bargaining or the plea negotiations referred to in section 162A may be initiated by an accused person or counsel for the accused person. So you see that in everything that it runs through the entire act, an accused person or counsel for the accused person. So the law even always starts with the accused person. The accused person. You negotiate with the accused person. When the accused person is represented by counsel,
but if you're
counsel.
if you are actually negotiating with the counsel for the accused, you are negotiating with the accused person. I mean, logically.
Then the law would not have put the accused person or counsel for the accused person logically, would it?
So what you're saying is that the law gives you a choice, either with the accused person directly or with the counsel. It's none is illegal.
One, the law gives you a choice, either the accused person or counsel for the accused person. But where the accused person is represented by counsel, you negotiate with counsel. But where the accused person is not represented by counsel, the law I've just read to you tells you that nothing stops you from negotiating with the accused person. In fact, an accused person can go to court and say, I don't want a lawyer. There are many instances. I'm in court right now in a case where the accused person is saying he doesn't want a lawyer. We are almost, judgment will be given in a few weeks' time. He did the whole case himself. He didn't have a lawyer. So in matters like that, is he forbidden from the plea bargaining law when the law is saying clearly that you can negotiate with the accused person or counsel for the accused person?
Right.
When you have a lawyer, when he had a lawyer, the Honorable Attorney General was negotiating with the lawyer. And there are letters out there to show that. I've seen these letters. I don't know how these letters got out there, but I've seen letters between the two parties where there's a negotiation going on between the Attorney General and counsel for, that was Thomas Sobin. He fired Thomas Sobin, sacked Thomas Sobin, and then the negotiation continued with him and the Honorable Attorney General, Jakpa, and the Honorable Attorney General, at the request of Jakpa, at the house of the relative of Jakpa. So it wasn't even a clandestine meeting. If it was clandestine, then it was clandestine against the Attorney General, not Jakpa.
All right. Isaac Wilberforce, Mensa, I'm grateful for speaking to us. If any clarity I need, I will definitely come to you. Thank you.